ask you about one of the purposes of this law? And I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization of our law.
Well, encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls.
If I could,
and that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
Your Honor, if I could make a few points. First of all, it sounds like the question is rooted in a potential improper purpose-based argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely, and I would love to address.
And what seems to have produced this classification is that we want to ban treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So the appreciate their sex reference detailed in legislative findings, that is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that has to be viewed in the context of the legislative findings, which both emphasize the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research and that assessment of whether the findings of that study, but the legislature specifically noted those studies, so I think that statement was rooted in the notion that actually this is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.